Saturday night specials, the case for affordable firearms.
To ban guns because criminals use them is to tell the law-abiding that their rights and liberties depend not on their own conduct, but on the conduct of the guilty and the lawless.
Jeff Snyder. Affordable firearms, often derogatorily referred to as Saturday night specials, include brands like Jimenez, Raven, Cobra, and High Point. While these are not top-of-the-line firearms, they serve an important and legitimate purpose: personal protection for people who cannot afford more expensive guns. In many cases, these inexpensive firearms are the only self-defense option for low-income individuals. Affordability and accessibility. Not everyone has the means to spend $500 or more on a handgun. The average cost of quality firearms can be prohibitive for many Americans, particularly those in low-income communities who may face higher risks of crime. A $150 or $200 handgun might be the only realistic option for someone who needs protection. Denying them access to affordable firearms effectively means denying them the ability to defend themselves. Self-defense in low-income communities. Many shootings and assaults take place in low-income environments where police response times may be slower and crime rates are higher. The people in these areas stand to benefit the most from owning a firearm for self-defense. The idea of banning cheap guns simply because they are more affordable is classist. It tells people that if they can't afford a more expensive firearm, they don't deserve the means to protect themselves. Gatekeeping self-defense. The argument against inexpensive firearms raises a crucial question. What price point is considered too low? Who gets to decide how much someone should spend on their personal safety? If we allow the government or certain political groups to dictate what firearms are acceptable based on cost, we are creating a situation where the right to self-defense becomes exclusive to those with financial means. Ineffective in reducing crime. Banning inexpensive firearms under the belief that they are predominantly used by criminals ignores the reality of crime. Criminals tend to obtain firearms through illegal means, regardless of cost. Most guns used in crimes are not Saturday night specials. In fact, studies show that Saturday night specials are used in fewer than 3% of crimes involving guns, and fewer than 2% of all such guns made are used in crimes. The false narrative. The notion that cheap guns are more likely to be used in crimes than expensive ones is not supported by data. Criminals do not care about brand names or price tags, they care about access. Banning affordable firearms does not stop crime, it simply disarms the law-abiding poor. This is an important reminder that gun control measures like this disproportionately affect minorities and low-income communities, leaving them more vulnerable to violence while doing little to actually prevent crime. Historical and social context. Gun control measures aimed at affordable firearms often have racist and classist undertones. Historically, gun control laws were used to disarm minority communities, particularly African Americans in the post-Civil War South. Today, the push to ban cheap guns disproportionately impacts the same communities. As Don B. Cates Jr. pointed out, gun prohibition is often the brainchild of privileged individuals who do not have to face the daily realities of crime in less affluent areas. They are insulated by wealth and private security, making it easy to dismiss the importance of affordable self-defense tools for others. Conclusion. Banning Saturday night specials is a misguided attempt at gun control that targets the wrong people. It does not prevent crime, but instead disarms those who need protection the most: law-abiding citizens in low-income communities. These firearms may not be glamorous, but they serve a critical purpose in ensuring that every person, regardless of their financial situation, has the ability to defend themselves and their families. Accessories are not covered by the Second Amendment. There is no such thing as the right of some men to vote away the rights of others. Ayn Rand. The argument that the Second Amendment doesn't cover accessories like magazines, ammunition, or bump stocks is a flawed and dangerous interpretation of constitutional rights. The idea is akin to claiming that the First Amendment doesn't apply to the internet because the founders could only foresee pamphlets and printing presses. Just as the internet is an extension of free speech, so too are firearms accessories an extension of the right to bear arms. The founders' intent. The Second Amendment was designed to protect the right of the people to bear arms for the purpose of defense, whether against criminals, foreign invaders, or even a tyrannical government. The idea that the government can dictate which accessories or how many rounds someone can use undermines the very purpose of this right. As Lawrence Hunter aptly stated, the Bill of Rights was created to protect individual liberties from government encroachment, not to grant entitlements to the government or the collective. Gun control advocates often overlook this context, focusing instead on restrictions that weaken these protections. Historical context. The founders were aware of advanced firearms technology, including repeating firearms, well before the Second Amendment was written. They were not limited to muskets, as some gun control advocates suggest. For example, the Kalthoff repeater from the early 1600s could fire multiple shots without reloading. The puckle gun, patented in 1718, was a type of repeating firearm that could hold 6 to 11 rounds. The Girardoni air rifle used by Lewis and Clark could fire 22 shots from a single charge, and the founders were aware of Joseph Belton's repeating rifle, which could fire 16 shots in 20 seconds. These examples make it clear that the founders were not ignorant of the potential for rapid fire or repeating arms, and they still chose to protect the right to bear arms without specifying limitations on firepower or accessories. Case law: protecting arms and accessories. Legal precedent supports the idea that the right to bear arms includes accessories. In Nunn v. State, 1846, the court held that the Second Amendment protected arms of every description. The Supreme Court's Bruin decision, 2022, further solidified this protection by clarifying that gun laws must align with historical traditions of firearm regulation. Under this framework, it is clear that modern restrictions on accessories like magazines and bump stocks fail to meet constitutional muster. Any argument suggesting that these regulations are legitimate misunderstands the Second Amendment's core intent and legal tradition. Bump stocks and the slippery slope of accessory bans. The bump stock debate highlights the dangers of regulating accessories. Bump stocks allow for a faster rate of fire while maintaining semi-automatic function, one shot per trigger pull. In the aftermath of the tragic Las Vegas shooting in 2017, where a bump stock was used, the ATF reclassified bump stocks as machine guns under the National Firearms Act, NFA. This move led to the first significant federal gun control under the Trump administration. While the tragic nature of the Las Vegas event cannot be overstated, banning bump stocks does little to enhance public safety. Rare use in crime. The Las Vegas shooting was the only known mass shooting where a bump stock was used. To put this in perspective, activities such as high school football and bee stings result in more deaths annually than bump stocks. Ineffective policy. According to a FOIA request, only 582 bump stocks were turned into the ATF as of 2019 out of an estimated million in circulation. This illustrates that banning accessories does not lead to widespread compliance or crime prevention. Furthermore, the logic behind banning bump stocks opens the door to further restrictions on other accessories. For example, states have proposed bans on trigger activators, like binary triggers, which allow firearms to fire on both the pull and release of the trigger. If we allow these kinds of bans, what is to stop lawmakers from targeting other firearm modifications, like custom triggers, muzzle devices, or even the type of ammunition used? The broader impact of accessory bans. The argument that accessories are not covered by the Second Amendment is part of a broader trend of expanding gun control measures. As history has shown, once a regulation is in place, it often leads to further restrictions. The 1934 NFA originally aimed to curb gangster-related crime, but ended up severely restricting ordinary gun owners by making short-barreled rifles and shotguns subject to heavy regulation. The 1968 Gun Control Act added the requirement that firearms have a sporting purpose, which is a clear deviation from the Second Amendment's intent to protect the right to bear arms for self-defense and resistance against tyranny. Accessory bans, like those on bump stocks, also serve as legislative stepping stones for more sweeping gun control measures. For example, in states like California, New Jersey, and New York, magazine capacity limits have been introduced under the guise of public safety, but have done little to reduce crime. Conclusion: the push to regulate firearms accessories, from bump stocks to magazines, is rooted in a misunderstanding of the Second Amendment. These measures infringe on the right to bear arms, and history shows they do little to reduce crime. Accessories, just like the firearms themselves, are covered under the Constitution, and the courts have consistently affirmed this. Moreover, restricting accessories fails to address the root causes of violence and instead erodes individual freedoms. As Bruin and other decisions make clear, regulations must align with the original intent of the Second Amendment, which was to ensure that Americans can protect themselves against both criminals and tyranny. Accessory bans do not meet this standard, and their enforcement will only lead to further erosion of gun rights. Manufacturer liability.
The rifle itself has no moral stature since it has no will of its own. Naturally, it may be used by evil men for evil purposes, but there are more good men than evil, and while the latter cannot be persuaded to the path of righteousness by propaganda, they can certainly be corrected by good men with rifles.
Jeff Cooper. The concept of holding gun manufacturers liable for crimes committed with their products is illogical and dangerous, as it targets a legitimate industry for the actions of individuals. This argument conveniently ignores the fact that, like all tools, firearms are morally neutral. They can be used for good or evil, depending on the intent of the user. This double standard is rarely, if ever, applied to other industries. For example, automobiles. Car manufacturers are not held responsible for drunk driving accidents. Alcohol. Breweries are not sued when someone drives under the influence and causes a fatal crash. Cutlery. Knife manufacturers are not held accountable when stabbings occur. And yet, when it comes to firearms, the ASDM crowd argues for holding gun manufacturers responsible for misuse. This hypocrisy becomes even more evident when we look at how politicians like Hillary Clinton have pushed for such liability protections to be removed, even though similar protections exist for other industries. Smith & Wesson's near collapse. One notable instance was Smith & Wesson, a respected gun manufacturer. During the Clinton administration, S&W agreed to include locking devices, limit magazine sizes, and stop advertising firearms as part of a settlement to avoid endless legal battles. This decision nearly drove the company to bankruptcy, as gun owners saw them as sellouts and boycotted their products. While some media outlets painted gun owners as unreasonable, this response was rooted in the recognition that S&W had been effectively blackmailed by the government into compliance. The company only recovered after a change in ownership and George W. Bush's support for lawsuit protection for gun manufacturers. Section 230, Comparison Communications Decency Act. An interesting parallel can be drawn with Section 230 of the Communications Decency Act, CDA. This section provides immunity to online platforms from being held liable for the content posted by their users. It essentially protects these platforms from civil liability, much like the Protection of Lawful Commerce in Arms Act, PLCAA, shields gun manufacturers from being sued for the criminal misuse of their products. When state attorney generals called for the removal of Section 230, the ACLU defended the provision, arguing that stripping these protections would stifle free speech online. This principle should apply equally to firearm manufacturers. Yet the same voices that defend tech companies often push for holding gun manufacturers liable for the actions of criminals. The bigger picture, America's arsenal. Beyond the legal and economic implications, there's a broader issue at stake: national security. The United States was once the arsenal of democracy, and the firearm industry played a crucial role in this. We cannot afford to destroy our domestic arms manufacturing industry through frivolous lawsuits, as it is essential to our homeland defense. Our military and civilian arms production have long been intertwined, with innovations from the private sector often leading to advancements in military weaponry. The AR-15, for example, was developed by Eugene Stoner and Armalite, not a government armory. If the firearms industry is weakened through constant legal battles, we risk outsourcing even more of our critical manufacturing capabilities. Just as we've outsourced much of our steel production and other industries, allowing our arms industry to be dismantled would be a grave mistake. A strong domestic arms manufacturing sector is vital not just for individual self-defense, but for national defense as well. Frivolous lawsuits, a threat to innovation. When manufacturers are tied up in legal battles, they cannot focus on innovation. Lawsuits force companies to divert resources from research and development to legal defense, stifling progress. John Browning, one of the greatest firearm inventors in history, understood this problem. He sold his designs to established companies instead of starting his own manufacturing plants, partly because he saw how much money Colt spent defending its patents in court. This focus on legal defense over innovation hampers the entire industry. The recent case of Remington's settlement with Sandy Hook families is a troubling example of the precedent this could set. Remington, under significant pressure, agreed to pay $73 million to the victims' families, even though the firearm used in the shooting was legally sold and the manufacturer was not at fault. This settlement sends a message that gun manufacturers can be held responsible for the actions of criminals, which opens the door for more lawsuits against companies simply making a legal product. Conclusion. Ultimately, the push to hold gun manufacturers liable for crimes committed with their products is not just an attack on the firearm industry, it's an attack on logic and fairness. No other industry is held to this standard, and the implications for both national defense and personal liberty are profound. We must protect our domestic manufacturing capabilities and ensure that frivolous lawsuits do not destroy an industry critical to our security. Manufacturer liability for criminal misuse of firearms is not just unconstitutional, it's fundamentally flawed reasoning that could have far-reaching consequences for the nation as a whole.